So we have been discussing the Parliament, and yesterday we started with our discussion on the Lok Sabha. In the Lok Sabha, we have seen the membership of Lok Sabha. We have also seen how members are elected to the Lok Sabha. We had also started with our discussion on the office of the Speaker. We have seen who is the Speaker, how the Speaker is elected by the Lok Sabha, what are the special powers that the Speaker enjoys, what is the special position of the Speaker, and then at the last we had discussed an office called as the Pro Tem Speaker. Now today we start with a discussion on special powers of the Lok Sabha. Special powers of the Lok Sabha. The first special power is with respect to Article 75 of the Constitution. Article 75 of the Constitution, under Article 75, Council of Ministers are collectively responsible to the Lok Sabha. Because Council of Ministers are collectively responsible to the Lok Sabha, only to the Lok Sabha, that is the reason why when we say confidence or no confidence motion, this confidence or no confidence motion can be passed only in the Lok Sabha. It can be passed only in the Lok Sabha. Second, with respect to money bill, a money bill can be introduced only in the Lok Sabha, and the Lok Sabha enjoys overriding powers in passage of a money bill. In case of money bill, the Lok Sabha enjoys overriding powers. Because once the bill is passed by the Lok Sabha, the Rajya Sabha cannot, by virtue of its powers, the Rajya Sabha cannot defeat the money bill, nor the Rajya Sabha can amend the money bill. Hence, we say Lok Sabha enjoys overriding powers in case of passage of a money bill. Under Article 352, a resolution seeking disapproval of the continuance of national emergency can be passed only in the Lok Sabha. Only in the Lok Sabha. If you see the special provisions or the special powers that are enjoyed by the Lok Sabha, the special powers that are enjoyed by the Lok Sabha are these three. First is when we talk about Article 75 of the Constitution. Article 75, we have previously discussed this. Article 75 of the Constitution says what? Article 75 of the Constitution says that the Council of Ministers are collectively responsible only to the Lok Sabha. How is this collective responsibility established? This collective responsibility is established through the provisions of confidence or no confidence motion. No, provisions of confidence or no confidence motion. Now, what is meant by this idea? Confidence and no confidence motion. For the Council of Ministers to continue in power, for the Council of Ministers to continue in power, as soon as the Council of Ministers are formed, they are formed, the oath is administered by the President. As soon as the oath is administered to the Prime Minister, the Council of Ministers have come into existence, we say that. But does that mean that the Council of Ministers have already established majority or confidence of the Lok Sabha? No. Oath, taking oath of the Council of Ministers, when Council of Ministers are taking oath, it does not mean that the Council of Ministers have enjoyed the confidence or are enjoying the confidence of the Lok Sabha. That has to specifically be proved. Whether the Council of Ministers enjoy confidence or not, it is proved in the floor of the Lok Sabha, on the floor of the Lok Sabha. And how is it proved? It is proved by passing of confidence or no confidence motion. By passing of confidence or no confidence motion. So, whenever the Lok Sabha meets, as soon as the Prime Minister and the Council of Ministers take oath, whenever the Lok Sabha meets, there is specifically, the Council of Ministers have to prove majority in the Lok Sabha. They have to prove that yes, they enjoy the numerical strength to continue as a Council of Ministers. And there is a motion passed there called as confidence motion. If they are able to prove, fine. Otherwise, there is it amounts to being no confidence motion. If they are not able to prove majority, what does that mean? It simply means that now the Council of Ministers do not enjoy majority. Hence, as soon as it is proved that they do not enjoy majority of the Lok Sabha, they do not enjoy the confidence of the Lok Sabha, what happens? The Council of Ministers go out of office. Clear? So, when we talk about confidence or no confidence motion, this confidence and no confidence motion can only be passed in the Lok Sabha. It cannot be passed in the Rajya Sabha. Did I say Council of Ministers are responsible to the Rajya Sabha? Did I say this? Did I say that the Council of Ministers are responsible to the Parliament? No. What did I say? Council of Ministers are responsible only to the Lok Sabha. Hence, to continue in office, they have to prove the majority. They have to prove that they enjoy confidence of the Lok Sabha. And how can they prove that they enjoy confidence? They can prove this by confidence motion. How can the opposition prove that the Council of Ministers do not enjoy the majority? Through the no confidence motion. Clear? So this motion, confidence or no confidence motion, it is passed only in the Lok Sabha. It is introduced and passed only in the Lok Sabha. Clear? Now, second is with respect to money bill. Now, I have discussed this provision earlier also. I am going to discuss money bill again. But for today, you will have to understand that anything that is a money bill, remember yesterday's class, how a bill becomes a money bill? Yes? By the speaker's, it should carry a speaker's, signature that this particular bill is a money bill. So, whenever we talk about a money bill, any money bill can only be introduced in the Lok Sabha. It cannot be introduced in the Rajya Sabha. Yesterday we did talk about the reason also. We said we were discussing the relevance of the Rajya Sabha, and that we said that when it comes to financial control, Rajya Sabha has limited financial control. Why? Because it is a council of states. The members are being elected from the states. They have their own financial authority. They have nothing to do with the union finances. So, with respect to money bill, the bill is only introduced in the Lok Sabha. The bill once passed by the Lok Sabha goes to the Rajya Sabha, and Rajya Sabha, by virtue of its powers, by virtue of its legislative powers, the Rajya Sabha neither has the power to amend the bill, neither the Rajya Sabha has the power to in any way defeat the bill. What Rajya Sabha can do is maximum Rajya Sabha can delay the bill for 14 days. They can delay the bill for 14 days. At the expiry of 14 days, if the Rajya Sabha has done nothing over the bill, it is deemed, it is considered, it is assumed that both the houses, the Lok Sabha as well as the Rajya Sabha, has passed the bill. Clear? So with respect to money bill, the Lok Sabha enjoys overriding powers. Third is with respect to it is with respect to discontinuance of national emergency. Discontinuance of national emergency. So to understand this, let's first understand what is national emergency, just a bit of it, and what is the procedure for imposing or proclaiming national emergency. So if we see Article 352 of the Constitution, Article 352 of the Constitution says that the President of India has the power to proclaim national emergency on 3 grounds: war, external aggression, and armed rebellion. Clear? If you remember, when we were discussing fundamental rights, I have discussed these 3 provisions. So when national emergency is proclaimed, if the President feels that there is a circumstance that exists which either has to do with war, or for that matter there is an external aggression, or for that matter there is an armed rebellion, the President of India can proclaim national emergency. Clear? Now, once national emergency is proclaimed by the President, as soon as national emergency is proclaimed by the President, there is a procedure that has been mentioned under Article 352 itself. What is the procedure? The procedure says that national emergency has to be passed, that proclamation has to be passed by both the houses of the Parliament It has to be passed by both the houses of the Parliament, by a special majority, and within 1 month or 30 days, to be more exact, within 30 days of the President proclaiming national emergency. It has to be passed within 30 days by a special majority and in both the houses of the Parliament. Clear? Once it is passed, once national emergency has been passed by both the houses of the Parliament by a special majority, it continues for 6 months. It continues for 6 months. And every 6 months, this process has to be repeated. Every 6 months, this process has to be repeated. Clear? Have you understood this? I am not discussing national emergency right now. I am just discussing the special power of the Lok Sabha. So to know what is this special power, you need to have some understanding of the background of emergency, and that is the reason why I am talking about these 4 points. National emergency can be proclaimed by the President on 3 grounds: war, external aggression, armed rebellion. Once the President proclaims national emergency, Article 352 also mentions the procedure. And what is the procedure? The procedure says that it has to be passed by both the houses of the Parliament by a special majority within 30 days. Once passed by both the houses by a special majority within 30 days, it continues for 6 months. Clear? Now, suppose this is a condition that national emergency has been passed by both the houses of the parliament and it is continuing for 6 months. However, it is not a compulsion that it has to continue for 6 months. Once passed, it continues for 6 months. But there is no compulsion that that emergency will have to continue for 6 months. That is not the case. So how can, within this 6-month period, if that particular condition on which the president had proclaimed a national emergency, if that is no more in existence, okay, that means the conditions of war or external aggression or armed rebellion, the ground on which the president had proclaimed national emergency, it is no more in existence. In that case, what has to be done? In that case, what has to be done or what can be done? In that case, the Lok Sabha enjoys some special powers. What happens? If 1/10 of the total members, if 1/10 of the total members of what? Lok Sabha, give it in writing to the speaker or to the speaker when Lok Sabha is in session, or to the president when the Lok Sabha is not in session, to the president when the Lok Sabha is not in session. Clear? So during this particular period, 1/10 of the total members, if they give it in writing, to whom? To the speaker. If the Lok Sabha is in session, Lok Sabha chal raha hai, it is in session, or to the president if it is not in session. If it is not in session, the speaker or the president will call for a special sitting, of the Lok Sabha within 14 days. Within 14 days, and if in this special sitting, if a resolution is passed, if a resolution to discontinue national emergency is passed by a simple majority, a resolution to discontinue national emergency is passed by a simple majority, the national emergency ceases to exist. National emergency ceases to exist. Clear? So in this case, see, Rajya Sabha does not do anything. The power is there with the Lok Sabha, not with the Rajya Sabha. Clear? See, I'll repeat this. Once national emergency is proclaimed by the president, it has to be passed by both the houses by a special majority within 30 days. Once passed by both the houses, it continues for 6 months. But the constitution does not say it will have to continue for 6 months. Even between the period of 6 months, the national emergency can be done away with. It can be discontinued with. How can this be discontinued? In this case, the Lok Sabha enjoys some powers. 1/10 of the total members of the Lok Sabha, if they give it in writing to the president or to the speaker, to the speaker when the house is in session, to the president when the house is not in session. So the speaker or the president will call for a special, they will call for a special sitting of the Lok Sabha within 14 days. It is compulsory for them. The president or the speaker will have to within 14 days call for a special sitting of the Lok Sabha, and in this special sitting, if through a simple majority a resolution to discontinue national emergency is passed, a resolution to discontinue national emergency is passed by a simple majority, the national emergency ceases to exist. National emergency ceases to exist. Clear? This is a special power of the Lok Sabha when it comes to discontinuance of national emergency. So when national emergency is proclaimed and it is passed by both the houses, it does not mean it shall and it has to continue for at least 6 months. At any given point of time, national emergency can be discontinued. How can it be discontinued? There are number of mechanisms, but one mechanism to discontinue it is when the Lok Sabha in a special sitting passes a resolution by a simple majority to discontinue national emergency ceases to exist. Understood this idea? Understood this idea? Clear? So when we say special powers, these are the 3 special powers that the Lok Sabha enjoys. First is obviously the power to hold the Council of Ministers collectively responsible. And how does the Lok Sabha do this? Through a confidence or through the no confidence motion. Clear? Almost all the prime ministers in India have faced a no confidence motion. All the prime ministers. Now, last year, in this last Lok Sabha, the Council of Ministers faced a no confidence motion. If you remember, the state of Andhra Pradesh, there is a political party there called as TDP, Telugu Desam Party. So Telugu Desam Party previously was an ally of NDA, and later on it withdrew its support from NDA. It withdrew its support from NDA. When it withdrew its support, it proposed a no confidence motion, that there should be a no confidence motion that should be brought in. It was passed. No confidence motion was brought in, but obviously it failed to pass because obviously the government enjoyed overwhelming majority. So out of the total 400 odd members who voted in the no confidence motion, 336 or 39 odd individuals voted in favor of the government. So no confidence motion did not pass. Manmohan Singh government that was there. Manmohan Singh government also faced no confidence motion during UPA 1 itself. What happened? The government of India signed a nuclear deal with US, and the left parties that were there, they were in opposition to it, and left parties was supporting, these left parties were supporting the government from outside. They were not participating. If you remember, we have already discussed these ideas. What is a minority government? So they were supporting the government from outside because the Congress party did not enjoy majority on its own. So it was there as a coalition government, and in this coalition government, they had additionally, this coalition government had a support of the left parties, and this left parties did not participate in the government. They were supporting the government from outside. They were supporting the government from outside. So what happened? The government signed a nuclear deal with US despite the fact that left parties were in opposition to it. Dr. Manmohan Singh said, no, India needs nuclear energy, and at whatever cost I am going to continue with it. The left parties withdraw their support from the government, UPA 1 government, and a no confidence motion was brought in. But the no confidence motion was not passed. Why? Because the UPA received the support of Samajwadi Party and some of its allies, and that is the reason why it did not pass. If we go back to Atal Bihari Vajpayee government, what happened? 13 days, for the first time Atal Bihari Vajpayee became the Prime Minister. He remained the Prime Minister for 13 days. On the 13th day, what happened? No confidence motion was passed. It was defeated. Then he again became the Prime Minister. This time he becomes the Prime Minister for 13 months. And again a no confidence motion is brought. It was passed. He was defeated by 1 vote. He also has faced no confidence motion. Similarly, if you see other during the 1990s, there are so many times no confidence motion was brought. I.K. Gujral, H.D. Dev Gowda, before that P.V. Narasimha Rao, all of them had faced the no confidence motion. Clear? Through no confidence motion, what is happening? The Council of Ministers, either they enjoy majority, they prove that they enjoy majority, or they prove that they do not enjoy, it is proved that they do not enjoy confidence, hence they go out of office. And this is taken, this very idea is taking place where? Only in the Lok Sabha, not in the Rajya Sabha. That is also the case for money bill. It is introduced only in the Lok Sabha, it is passed by the Lok Sabha. It does not mean that the Rajya Sabha does not debate and discuss money bill. They debate and discuss money bill, but they do not have, even if they vote against the bill is defeated, but Lok Sabha enjoys overriding powers. And finally, with respect to discontinuance of national emergency, these are the three instances in which the Lok Sabha enjoys some special powers. Clear? Understood this idea? Now give a subheading and write disqualification of members of parliament. Disqualification of members of parliament. So, Article 102 of the Constitution deals with disqualification of the members of the parliament. Clear? It explicitly mentions what are the grounds on which an individual can be disqualified from being a member of the parliament. These grounds are also extended to the members of the state legislatures or legislatures of the UTs. The same grounds are extended there as well. So let us see what are the grounds that have been mentioned under Article 102. Clear? Write this. Article 102 provides the following grounds. Article 102 provides the following grounds. The following grounds of disqualification of members of parliament. First, if he holds any office of profit, if he holds any office of profit under the government of India, or under any state or any other state other than those offices declared by the parliament by law, not to disqualify its holders. Underline office of profit. Add one more thing in the next paragraph, same point. The parliament has passed parliament in brackets prevention of disqualification of membership act bracket closed act 1959 which exempts certain offices from being office of profit. So see, if you look at Article 102 specifically says that any individual who holds any office of profit, that individual is to be disqualified from being the member. So when we say office of profit, if you look at how office of profit has been mentioned, it says office of profit under the government of India or the government of state, which means that office of profit does not include any kind of private, what you can say, private job, or for that matter a business or any such thing. That is not included as a part of office of profit. That is not included as a part of office of profit. So if I am elected to being a member of parliament and I have a private business, I also have the right to continue with that particular business. Similarly, if as an individual I am participating in any other kind of economic activities from which I am going to benefit, I have absolute right to do it. Yes. What I cannot do is I cannot enjoy any office of profit under the government of India or under the government of state. However, there are certain offices under the 1959 law, certain offices have been exempted from being office of profit. Clear? Interestingly, neither the constitution nor the law defines what is office of profit. The constitution also does not define what is office of profit, what amounts to office of profit. Neither there is this law which exempts certain offices from being office of profit. Neither the law defines what is office of profit. The Supreme Court has defined office of profit. Clear? In next paragraph, right? However, neither the constitution nor any law defines office of profit. The Supreme Court in Shibu Soren versus the Union of India, 2001 case has defined what is an office of profit. What is an office of profit? The court states that if the office satisfies any of the following. First, if the government makes appointment to the office, Second, if the government has the right to remove the holder of the office. Third, if the government pays remuneration. Fourth, the functions performed by the holder of the office are governmental in nature. And the next point, the last point, the government exercises any control. Over the performance of such functions. Next paragraph. The Supreme Court further clarified that the office of profit need not necessarily confer benefits on its holders. It is sufficient if the office confers it is sufficient if the office confers administrative and executive powers, on its holders. Clear? So the Supreme Court is very clear with respect to what office of profit is, despite the fact that there is no law in India which defines what office of profit is, but there definitely exists the decision of the court, and the court says that if any particular office wherein appointment, or for that matter removal, or for that matter the nature of function is governmental, or if the compensation is paid, that is governmental, or for that matter even if the compensation is not paid, any kind of benefit is not derived, but the concerned individual, the concerned holder, if that individual is enjoying any kind of administrative or governmental functions, in that case that will amount to being a office of profit. Clear? Now go back to our discussion on parliamentary secretaries. If you remember, we had talked about parliamentary secretaries when we were discussing Council of Ministers. What did I say? Aam Aadmi Party appointed 21 individuals as parliamentary secretaries. Initially when it was accused that these are office of profit and they should be disqualified, the first argument that was given by the members of Aam Aadmi Party was this, that they are not receiving any kind of benefit from the government, they are not receiving any kind of salary etc. from the government. But that argument does not stand. Why? Because even if they are not receiving any kind of benefit, no salary, no monetary compensation, that does not matter. That is not the only grounds on which our office is classified to be an office of profit. Even if they were performing certain functions which are governmental in nature, that will automatically be categorized as office of profit. And that particular argument does not stand. Technically speaking, yes, it was an office of profit, but because there was a mistake made by how the election commission approached this, that was the only reason why they were not disqualified. Clear? Understood what is office of profit? Remember Shibu Soren versus the Union of India, 2001. In 2001, Shibu Soren was disqualified from being the member of parliament, and in that, when it was appealed, this was the decision of the court. Clear? So the first provision that has been mentioned under Article 102 is office of profit, and now we know what is office of profit. Second point. If the member of parliament is of an unsound mind, and is so declared by a competent court, clear? So if an individual is of unsound mind and is declared of unsound mind by a competent court, by a competent authority, he is also disqualified. Third point, if he is adjudged to be an undischarged insolvent, what is the meaning of this term, undischarged insolvent? Yes? Bankrupt? No. If you are an individual who is bankrupt and you claim bankruptcy, now you have claimed, because in India now we have a law, IBC, Indian Bankruptcy and Insolvency Code. So if you claim bankruptcy, you can still become a member of parliament. What is then the meaning of adjudged insolvent? It means if an individual has not been able to pay his dues, in his due course of business. That means he is continuing in business and he is not able to he is not able to pay his dues. He has declared that he will not be able to pay his dues. That individual is to be that individual is an undischarged insolvent. Not just being an insolvent, it means undischarged insolvent, which means you have not paid your dues. In the normal course of business, you have not paid your dues. In that case, you can be disqualified. An individual who claims to be bankrupt and has claimed bankruptcy, he is an insolvent but not undischarged. He is a discharged insolvent. So he can become a member. Only an undischarged insolvent cannot become a member. Clear? Undischarged insolvent also does not mean if you have a loan from the bank. You know, bank mein loan hai, so because I have a business and I have a loan from the bank, so I am an undischarged insolvent. No. If you are continuing to pay your loan, you are continuing to pay off your dues, you are not an undischarged insolvent. Clear? Next. If he is not the citizen of India, if he is not the citizen of India or is under oath of allegiance, to any foreign state, if you look at if you go through the Representation of People's Act 1951, it specifically states that only a voter can be elected. So if I am not qualified to be a voter in this country, I am also not qualified to contest elections and hold such positions. So if it is proved that at any given point of time, if it is proved that I am not the citizen of this particular country, in that case I am automatically disqualified from the legislature. Dekho, whenever elections approaches, so there is a controversy that starts that Rahul Gandhi is a British citizen. You will find that this is something that goes on. Dekho, now elections are over, no one is talking about it. As soon as elections will approach, you will find that everyone starts talking about Rahul Gandhi being a British citizen. Why? Because if he is a British citizenship, if he has British citizenship, we know in India dual citizenship is not allowed. And we know that on the basis of any individual who has voluntarily accepted the citizenship of any other country, his citizenship in India is terminated. His citizenship of India is terminated. So if it is the case that Rahul Gandhi is a citizen of any other country and there is proper documents to prove that he is a citizen of any other country, in that case he no more is a member of parliament, he is automatically disqualified. That is the reason why you will always find that during elections, this issue starts that he is a British citizen, he is not a citizen of India, etc., etc. Clear? Next. If he is disqualified, under any law made by the parliament, if he is disqualified under any law made by the parliament, which means what? Parliament can also enact laws and prescribe qualification, that who are qualified to be members and who are not qualified to be members. And in certain cases they may consider individuals with certain kind of individuals can be disqualified from being members of parliament as well. If you remember, I have also talked about something called as Representation of People's Act. Representation of People's Act 1951 and Representation of People's Act 1951 specifically talks about this. It specifically says that any individual who is convicted of a criminal offense and is liable to serve a sentence of 2 years or more, at least 2 years. In that case, not only is he disqualified from serving, for 2 years, that means the time that he is serving that sentence, he is further disqualified for 6 years, which is a cooling off period, which means during this particular time, 6 years plus 2 years, for 8 years he is disqualified. Clear? Now this is a law that has been enacted by the parliament, and this law prescribes a certain qualification that you should not be a convicted criminal. If you are a convicted criminal and the conviction is such that you are liable to serve a sentence of 2 or more years, in that case you are not only disqualified for the time period of sentence, but you are also disqualified for an additional term of 6 years. Clear? So this is a law that has been made by the parliament, and the parliament can enact such laws prescribing for some additional qualifications. Clear? Now before we go to such, one of such laws, just in the next paragraph right here, under Article 102, the disqualification of the members of parliament, are done by the president on the recommendation of the election commission. Clear? Underline this. This is a very important fact. Who disqualifies members of parliament? The president. And how does that happen? On the recommendation of the election commission. Clear? This is how an individual is disqualified under Article 102 of the Constitution. When we talk about disqualification, because we are talking about disqualification, let's also discuss a law that has been enacted by the parliament, which is called as Anti-Defection Law. So give a subheading right here, Anti-Defection Law. Anti-Defection Law. What is Anti-Defection Law? Anti-Defection Law basically deals with something called as political defections. Now, see, if you go back to our discussions in the last 2 or 3 classes back, we did talk about something called as political defections. We did talk about 1967. We did talk about coming up of various other political parties started enjoying powers in the state since 1967, and since 1967, with the coming up of multi-party democracy, India was always a multi-party democracy. The only thing was that since 1967, these other political parties that were there, they started enjoying powers. Now because of coming up of this political parties in a multi-party democratic system, and these political parties started enjoying power, one negative that appears because of a multi-party system, a multi-party democratic system, is the phenomena of political defections. It is still prevalent. So we are also going to, after our discussion on anti-defection, we are also going to scrutinize the anti-defection law. So when we talk about this idea of political defections, what are these? What is a political defection? See, in 1967, there was a case that came up in the state of Haryana, and what happened was, there was one of the leaders of the Congress. His name was Gayaram. In one day, he was able to switch 4 political parties. After election results were announced, in the morning he went from Congress to another political party. By afternoon he was in the 3rd political party. By evening he was on the 4th political party, and by next morning he returned back to Congress. He returned back to Congress. This was the reason why in Hindi there is a phrase called as Aaya Ram Gaya Ram. It was actually coined after this very incident wherein Gaya Ram changed 4 political parties within 24 hours. And that is the reason a phrase was coined, Aaya Ram Gaya Ram. And this idea of political defections, that means shifting from one political party to the next political party after election results have been announced, not before that. After election results have been announced, that is this is the phenomena of political defections. So what used to happen, now you must have heard about what was currently going on in Maharashtra, or what has happened in Karnataka also. It is clear, it is clearly a case of political defections. It is clearly a case of political defections when politicians from one political party, once they get elected from that political party's ticket, they do what? They change political parties. They change political parties. Why? Because of various reasons. In certain cases, some of the members of the winning political party, they are not satisfied with the portfolio that is allocated to them. So they do what? They, along with some of their members, they shift from one political party to other on this very condition that you are going to allocate the same, these portfolios to us. If you are going to do that, we are going to shift to you, we are going to support you, and accordingly the people who have voted for one political party, rather than that political party coming to power, what happens is the another political party misusing this particular idea of political defections, they were able to enjoy power. Similarly, the use of money power, the use of muscle power, the use of this money and muscle power, and also horse trading. These were certain things that became very common to Indian politics. Why? Because of the coming up of the multi-party democratic system in India. That the multi-party democratic system, it gained its root. It became very strong in India. And political parties, like you will always find now India is truly a multi-party democratic system. You can see yesterday I was giving you an example of how in the elections, or just 6 months ago, in the elections to the parliament, the BJP was able to win. BJP was able to win in the state of Jharkhand, except barring one particular seat, all the other seats were won by the BJP. And now yesterday when election results were announced, we found that the BJP was they were not able to win the state legislative assembly. This was something that became very prominent in the 1960s. Since the late 1960s, political defections, it was something that was very prominent. In the background of these political defections, because of this political defection, there was also something called as political instability. Now, because of political defections, political instability becomes a very important factor. That okay, people have voted for a stable government, or if you look at if you look at the state of Maharashtra, people have voted for a stable coalition government, wherein somewhere around 105 seats were enjoyed by, it was given to the BJP, and its coalition partner, that is the Shiv Sena, enjoyed somewhere around 55 or 50 odd seats, which means a total of more than 155, and the halfway mark there is 145. Clear? So there they require, I think 288 or something is the total seats in the legislative assembly. So they require a 145 number for majority. So people have voted for a coalition, a stable government. But what used to happen previously, what used to happen was that these political parties, because they were not able to satisfy the members, their own members, these members did what? They used to shift political parties. Sometimes because of the use of money and muscle power, sometimes because of horse trading and portfolio allocation. And this led to political instability. Why? Because on one day they are on this political party, okay, they are guaranteeing, okay, I am going to give you this portfolio. The next day when their political party, their own political party from which they have defected, if they guarantee, okay, you come back, I am going to give you this position, so they are back there. These political defections lead to political instability. And this political instability is one of the factors, one of the reasons why even our parliamentary democracy and our democratic system has been a problem. To get rid of these political defections, to get rid of these problems, in 1985, we took up a constitutional amendment called as the 52nd Constitutional Amendment Act in 1985, and this act also added the 10th schedule to our constitution, and this is what is called as the Anti-Defection Law, which means if there is political defections, if there are political defections which do not, or which leads to political instability, or defections which are not ideological, they are for some short-term gains, such as some political positions, or for that matter use of money and muscle power. There was, that is this 10th schedule Anti-Defection Law, the 52nd Constitutional Amendment. It was brought in to come up with a legal mechanism to stop this political defection. That is the reason why we have enacted for something called as an Anti-Defection Law. We have enacted for something called as an Anti-Defection Law. Clear? Have you understood this idea? Now, what does the law say? When we say that Anti-Defection Law is able to do what? Anti-Defection Law is able to stop political defections, or it is there to counter political defections. So what we need to look, what we need to see is how does it do that? What are the provisions? So if you look at the provisions of the 52nd Constitutional Amendment, the 10th schedule, it has added that any individual who has been elected to the legislative assembly or to the parliament, that is, either you have been elected as a member of state legislative assembly or as a member of parliament on a particular party's ticket. That means you have been voted to power on that political party's ticket. You cannot resign from that political party. If you resign from that political party, you may be disqualified. You can be disqualified from the concerned legislative assembly or the parliament. Second, not only you can not resign from that political party, you cannot join any other political party. You cannot also join any other political party. If you join any other political party, again you can be disqualified. Clear? Thirdly, it also says that you will have to adhere to party discipline. How can you, or how will you adhere to party discipline? You will adhere to party discipline in this format, in this mechanism. Political parties tend to issue whips when there is an important issue that is going on within the political party or in the parliament. So they tend to issue whips. When we say whip, this is the whip. They tend to issue whips. What is a whip? Whip is a general direction. It is a general direction that is given to the members of a political party. All the members of that particular legislature of a political party. And no individual who has been elected on that political party's ticket can defy the whip. If you defy the whip, in that case what happens is you can again be disqualified, provided that the political parties do not condone your action. What does this mean? I'll explain this. If you have read the newspapers, yesterday's newspaper, or I think today's newspaper, you might have heard about a news wherein Mamata Banerjee had condoned, she has condoned the actions of her 10 MPs. Her 10 MPs who were not present during the CAB bill was being passed in the Lok Sabha. Have you heard, have you read the newspaper? Now, what does it mean? See, when a political party issues a whip, it means that you have to follow the whip. The whip may be in this regard: you are to be present during this particular day, during this particular bill when it is being discussed in the parliament or when it is being voted upon. The whip will say that all the members of this political party will have to be present in the house when this voting is going on. You have to be present there. Or the whip will also say you have to vote in this manner. You have to vote in this manner, either yes or no, in favor of the bill or against the bill. The whip will give directions to the members of the legislature belonging from that political party. The members, they are to be given certain directions, and you will have to follow those directions. If you do not follow those directions, you can be disqualified from the house, provided your party does not condone your action within 15 days. So if you have not acted in accordance to the whip, in that case the political party that you belong to, your political party will have to condone. That means they will have to agree. They will have to agree that okay, fine, though these individuals have not they have not adhered to the whip, but still their actions, we as political parties, we condone, we consider their actions to be correct. So if you do not follow the party whip, in that case the option is that within 15 days the political party has to condone your action. If they do not condone your action, you are again eligible to be disqualified. Similarly, there are some nominated members. We have already seen that in the Lok Sabha there are 2 nominated members, in the Rajya Sabha there are 12 nominated members. These nominated members are given a period of 6 months to join a political party. That means once they have been nominated to the house, they are given 6 months that you can join a political party within 6 months. If you join a political party within 6 months, it is fine. But if the 6-month period has lapsed and then you are going to join a political party, again you are scheduled to be disqualified. It's very likely that you are then disqualified. So you cannot join a political party after 6 months if you are a nominated member. Similarly, an independent candidate, that means a candidate who has been elected to the legislature, the candidate who has been elected to the legislature on no party's ticket, that individual cannot join a political party. If the individual joins a political party, that individual is also scheduled to be disqualified, becomes eligible for disqualification. Clear? So when we talk about what is anti-defection law? Anti-defection law talks about these ideas. It says that any individual who has been elected to the legislature from a political party cannot resign from that political party. Any individual who has been elected to the legislature from a political party cannot join any other political party. Any independent candidate cannot join any political party. Any nominated member can join a political party only within 6 months. After 6 months, if he joins a political party, he can be disqualified. And you as a member of a political party cannot defy general directions given by a political party to the members of the legislature. If that is done, in that case the individual again becomes scheduled to be disqualified. Again that individual will be disqualified, provided 15-day period. Within 15-day period the political party condones such an action. Clear? If these three things are there, these 5 points are there, if you defy any, or for that matter if we talk about use of sometimes MPs are being forced, right? Like if you have seen what has happened in Maharashtra, क्या होता था? Now Congress party, all the members of Congress party उनके phone ले लिए गए, and they have been stuck in one of the 5-star hotels. Why? Some or the other mechanism to stop that political horse trading that is going on. For that, anti-defection law has been imposed. However, anti-defection law also provides for certain exceptions. It also provides for certain exceptions. What are those exceptions? First, obviously if a nominated member joins a political party within 6 months, he is exempted. Second, if there is a political party and at least 2/3 members of a political party either split or merge with any other political party. So 2/3 members, provided not less than 2/3 members. I'll give you an example. Recently, you must, when I say recently, again it's an year-old story. Now in the state of Goa, there is no opposition. You know this. In the state of Goa, previously there were two political parties, major political parties, BJP and Congress. And there are few independent candidates. So what happened was the BJP was able to form the government through the help of these independent candidates. Then the Congress, the MLAs who were elected from the party, from the ticket of Congress party, all of them joined BJP. All of them joined BJP. Now this is allowed. This is allowed under anti-defection. It provides that 2/3 members, if a political party, minimum of 2/3 members who are elected to the legislature, if they join or they split, that means not only they will have to join a political party, even if they split and form a new political party. If they split and form a new political party, or for that matter they split and join a political party, they are not eligible for disqualification. And that is the reason why today we do not have even one member, even one MLA in Goa who had actually contested. They won elections. They were able to win elections on the ticket of the political party of Congress. But there is currently no member of Congress in the Goa legislature. Why? Because all of them, what does anti-defection law say? Minimum 2/3. Here there are 100%. They have all joined the BJP. So there is no Congress party in Goa. Similarly, if you take the example of yesterday Jharkhand results were announced. Previously, if you go back to the last, in the last elections, what happened was BJP was able to win only 37 seats out of the 81, which means they required 41 for government. They were able to win only 37 seats, and they received support from a coalition partner, AJSU. Then what happened was there were 6 members of a political party called as JVM, Jharkhand Vikas Morcha, who were able to win elections. Out of them, 4 of them joined the BJP. Out of 6, 4 of them joined the BJP. So 2/3, that criteria is qualified, so they were not eligible for disqualification. So it says at least 2/3 members, if they split from a political party or if they join a political, they merge with some other political party, that is constitutionally allowed. Previously, this criteria was not 2/3, it was 1/3. When you look at the original constitutional amendment, it was only 1/3. This was later on rectified and it was made 2/3. By the 93rd Constitutional Amendment Act, it was made 2/3. Clear? Second. Third, sorry. First is a nominated member. Second is if there is a split or a merger. Third is if the members of a political party who on becoming the member of the legislature has been appointed or has been elected as speaker, deputy speaker or deputy chairman of the speaker and deputy speaker of Lok Sabha or deputy chairman of the Rajya Sabha or speaker, deputy speaker, chairman or deputy chairman in the state legislature. So in those states which have only one house, for them the speaker and deputy speaker, and for those states which have two houses, that is they also have a state legislative council, there they will have chairman and deputy chairman as well. So those individuals who are elected to these offices, that is if they are a member of, they are elected to being a speaker or a deputy speaker or deputy chairman of Rajya Sabha or speaker or deputy speaker of state legislative assembly or chairman or deputy chairman of state legislative councils. So if you are elected to such positions, in this case if you decide to resign from your political party, if this case you resign from your political party, you are not eligible for disqualification, provided whenever you leave that particular position, that means now if you are no more the speaker or the deputy speaker or the deputy chairman or the speaker or deputy speaker in the state legislative assembly or the chairman or deputy chairman in the state legislative assembly, if you decide to leave this particular position, then you will have to join the same political party from which you have resigned. If you adhere to these, then in that case such presiding officers are not subjected to disqualification even if they resign from their original political party. Even if they resign from their original political party. Like you will seldom find this happens. Let's take an example. Who is the current speaker? Has he resigned from BJP? No. He is still a member of BJP. He is still a representative of BJP in the Lok Sabha. Last Lok Sabha, who was the speaker? Sumitra Mahajan. She also did not resign from the political party. She continued. However, if we go back, around 10-15 years, that in that case you would find that in the UPA 1 government, during the UPA 1 government, Somnath Chatterjee was elected as the speaker of Lok Sabha, and Somnath Chatterjee belonged to the left parties. He resigned from the left parties. He resigned. He did not join any other political party, which means there are two conditions that you have to satisfy. If you resign from a political party, two conditions. First, you do not join any other political party. Second, if you leave such a position, if you give up such a position or you are removed from such a position, in that case, you again rejoin the same political party from which you were elected to the house. If you do this, in that case, your position is also exempted from being disqualified. Clear? Have you understood this? So this is what is the anti-defection law. Before I get into more details of anti-defection, first you write this. It's easy to remember if you revise and if you are able to understand what I am trying to say. If you are able to understand, you will never forget these provisions. Clear? Political defections. Have you written this? 52nd Constitutional Amendment Act 1985 added 10th schedule to the Constitution. After that you can write. It seeks to prohibit political defections. It seeks to prohibit political defections for personal gain. For personal gain by providing for disqualification by providing for disqualification of members of legislature, Under this act, legislators can be disqualified. First point here. If an independent member joins a political party. Second, if a nominated member joins a political party 6 months after having become the member of the house. Third, if a legislative party member resigns from his political party. Fourth, if a legislative party member joins any other political party. Fifth, if a legislative party member votes against a whip issued by the political party, or abstains from voting by violating his party whip and his action is not condoned by his party within 15 days. See, sometimes you may hear, you may read about this in the newspaper also, that an individual has been appointed as a party whip in the Lok Sabha or in the Rajya Sabha. What happened during August? In August, what happened was in the Rajya Sabha, the party whip of the Congress party, he himself voted against the party whip. When this Article 370 and in the in provisions with respect to Article 370 and in the reorganization, J&K reorganization bill that was presented. So in that case, the party whip of the Congress in the Rajya Sabha voted against his own political party, accusing the Congress that this is something that is that should not be done. This kind of line should not be taken by the Congress party, and this is something that is concerning the country at large, and hence we should support the government. He resigned from the political party and voted against his own political party on this particular ground. See, when we say party whip, sometimes an individual member of the concerned house is appointed as a party whip in the house. What is a party whip? That individual is responsible for ensuring that every member of the political party in the house adheres to what the party's direction was. So whip is an officer, whip is also general direction. When we say whip, he is appointed as a whip, it simply means that he is appointed as an individual who has the duty to ensure that party's direction is carried out on the floor of the house. That is what he does. So he ensures, no, politically he will ensure that every member of his political party has voted in accordance to what the party whip is. Clear? So he can be appointed. You must, you sometimes, some or the other time you will definitely hear about this. Specifically during the legislative sessions that are going on, you are going to hear about this. That this individual has been appointed as a party whip. There is no scope for confusion there. He is just the individual who is responsible for ensuring party discipline on the floor of the house. That is what he does. So he will ensure that every member of the political party is acting in accordance to the direction that has been given by the concerned political party. Clear? Now give a subheading here, write exceptions. Exceptions. First, if a nominated member joins a political party, if a nominated member joins a political party within 6 months of his nomination, within 6 months of his nomination. Second, if not less than 2/3 of the members of a legislative party, 2/3 of the members of a legislative party break away or merge with another political party, they shall not be subjected to disqualification. They shall not be subjected to disqualification. Third, if a member on being elected, as the speaker or deputy speaker of Lok Sabha or the state legislative assemblies, or the deputy chairman of Rajya Sabha, or chairman or deputy chairman of state legislative councils resigns from his political party and does not join any other political party and rejoins the same political party from which he originally resigned, on giving up his office, shall not be disqualified as a member. Clear? So these three are exemptions from the anti-defection law. Let's look at the one very important provision of the law, which is called as the paragraph 7 of the anti-defection law. So give this subheading here, paragraph 7. Very important. It's very important. Now, paragraph 7 of the law, what does it say? First write this down. It states that the presiding officer of the house shall be the final authority to decide the final authority to decide on the question of disqualification, on political grounds, and his decisions shall be final and binding, Clear? Now, why is this important? Yes, why is this important? So, if they went to the Supreme Court and why, that is absolutely fine. What you said is fine. Why? What I am saying is, why is this provision important? What is the importance of paragraph 7? Final, that is what you have written. What I am asking is, what is the importance of this provision? My question is, if you look at the paragraph 7 of the law originally stated that the authority to disqualify an individual from the house on political grounds lies with the presiding officer, which means in Lok Sabha it is the speaker, in Raj Sabha it is the chairman, in state legislative assembly again it is the speaker, and in state legislative council again it is the chairman. So the presiding officer has the power to do what? To disqualify the individual on political grounds. That means when he is defected from a political party on what you have just mentioned, the conditions, if he satisfies any of those conditions, the authority lies with whom? The Speaker of the House. The Speaker or the presiding officer disqualifies. And the original law, paragraph 7 of the original law said that the presiding officer's decision shall be final and binding, which means what? It cannot be challenged. This is what is the meaning of final and binding. Now, when I say what is the importance of this provision, what I am asking you is, if you look at the paragraph 7 of the law, what do you see? What is the importance of this particular provision? Okay. Compare this provision to the disqualification under Article 102. How is disqualification under Article 102 done? By the President on the recommendations of the Election Commission. So there, that means except for defection, political defections, anti-defections, the disqualification is done by the President. And how does the President do that? The President takes up disqualification by disqualifying an individual on the recommendation of the Election Commission. And here the disqualification is being done by whom? It is being done by the presiding officer. Why is this the case? What do you think is the reason? Okay, do you think it is appropriate for the presiding officer to disqualify? Do you think it is appropriate for the presiding officer to disqualify an individual? Yes or no? You should have an opinion. Okay? After so many classes, at least you should, by now, my understanding is you should understand at least 10% of what I am teaching. If you understand 10%, you will understand what I am trying to say. Should the presiding officer be responsible? Should the presiding officer be the decision-making authority? Why? Absolutely correct. In India, when we talk about the presiding officers, presiding officer of whether it is the Lok Sabha, the Raj Sabha, even the vice president, despite the fact that yes, vice president We consider the vice president to be because the vice president of India, but what we are forgetting is that even the vice president may be a political entity. Venkaiah Naidu, before he became the vice president, he was the minister in the same government. He was the urban affairs minister. And this is not the only case. There have been so many instances in which the vice president that has been appointed, the vice president is a political entity. Okay, leave the vice president. If you look at the Speaker of the House, the Speaker of the most important authority here is the Speaker, whether it is the Lok Sabha or the state legislative assemblies. And is the Speaker in India a politically neutral office? Is the Speaker in India a politically neutral office? Absolutely not. Speaker in India, unlike the Speaker of the House of Commons in UK, is not a politically neutral office. It's not a politically neutral office. I have just given you an example. How Om Birla, who is the current Speaker, he continues to be the member of BJP. Similarly, if you look at the previous Speaker, Sumitra Mahajan, she served 5 years as the Speaker of the House and she continued to be a member of the political party. How are the speakers elected? They are elected through a majority. And generally the Speaker, the office of the Speaker is an individual who who enjoys some important position in the ruling party. So the Speaker is always a biased position. It's not a neutral position. We cannot expect the Speaker of the House to be neutral. And when we give such a power to the Speaker of the House, in that case, what happens? These authorities, these individuals the Speaker of the House, the presiding officer may use the provisions to benefit one political party over the other. It may benefit one political party over the other. And the best example for this is what happened in Karnataka. The best example. See, I'll give you the situation, you will understand. And you will understand the beauty of how politics is being taken up. So, when election results were declared in Karnataka, BJP was able to get 102, somewhere around 102 seats. The majority mark was 112 or 13, something like this. So they were 10 seats short of the majority mark. And the other two parties were the Congress party and the JDS, Janata Dal Secular. JDS has a background, a political background with the BJP. H.D. Kumaraswamy there was a similar condition that appeared in Karnataka around 20 years ago, somewhere around 20 years, 15-18 years ago. And at that particular moment, H.D. Kumaraswamy became the chief minister through the support of BJP. And BJP withdrew the support during his tenure. So support was withdrawn by BJP. So he was not to join BJP, obviously, but politics में ऐसा कुछ होता नहीं है that he is not going to do this. But it was very likely that he was not to take up the support of BJP, and hence he was supported by the Congress party, and through the Congress party he joined he became the chief minister. Now, there are two things that you need to understand here. Now, to prove the majority in the House, there are two things that can happen. First, if suppose 15 members of the House, they resign. 15 members of the House resign. What is going to happen? The total strength decreases. So if suppose the majority mark was 213, which means the total 113, which means the total number of seats is 225. If suppose the 15 members resign, what is going to happen? Now what is the majority mark? It is No, 200. The total strength is 210. So the majority mark is 105. Majority mark is 105. No more it will be, no more it will be 113. The majority mark decreases from 113 to becoming 105. Clear? This is what happened in Karnataka. So BJP, because of the working of the JDS and Congress party, first of all, the members of JDS, Janata Dal Secular, they were not happy with how the Congress party was, how the Congress party was supporting them. So almost every day, there were some news about, how the Congress party wanted the previous chief minister, that is Siddharamaiah, to become the chief minister instead of Kumaraswamy. And they even frequently in the media, they were talking about how he should be replaced as the chief minister. This led to the members of JDS and the members of Congress party, they were not happy with each other. BJP used this. What did they do? They ensured that 18 members of the Congress party resigned. Now 18 members of the Congress party resigns. Now as soon as 18 members resign, what happens? The majority mark goes down and BJP had 102 seats. Which means if 18 to 19 members resign, BJP gets majority. So they did what? They did not say that you join us. They did not compel them to join us. What they did was, they made them resign. Because these members were those individuals who were likely to win elections, whichever political party they contest from. It was not that they are going to contest from a political party and only then they are going to win. They will either they contest from BJP or they contest from Congress, it does not matter, they are going to win elections. So what did the BJP do? They recognized these individuals who can win elections and they made them to resign from the Congress party, because as it is, they were not happy with the chief minister. The Congress party, which had more number of seats, JDS had only 35 MLAs. And Kumaraswamy, who was the leader of JDS, was the chief minister. So the Congress party had somewhere around 70 to 80 MLAs. So the chief ministers should be from the Congress party, not from the JDS. So they were not happy with the working of the Congress party. They were not happy with the coalition, and that is where BJP told them to resign. Clear? How does an individual resign when he is a member of parliament or a member of the state legislative assembly? He resigns by addressing the resignation to the presiding officer. Who is the presiding officer? The speaker. Now the speaker was from Congress. He knew that as soon as I accept the resignation of these individuals, the concerned political party, the concerned individual, the concerned political party, the coalition that is there, it loses majority of the lower house. So what did the speaker do? The speaker did not accept their resignation. Clear? Now see how the speaker is a biased authority. What I am trying to tell you is this. So the presiding officer did not accept the resignation. This matter continued. And what happened was, because they did not accept the resignation, so now these individuals defected from one political party to the other. Though they did not join the BJP, but they defected against the Congress party itself. This was appealed in the Supreme Court. The role of the speaker was appealed in the Supreme Court. The MLAs of BJP, they went to the Supreme Court that see, they do not have the majority, but the speaker is not allowing for a trust vote. The Supreme Court ordered a trust vote, that yes, in this, on this day you have to have a trust vote. But the next idea was whether these individuals who have already defected from the party, whether they will be allowed to vote in the trust vote or not. So they said, it does not matter, you allow us or you don't allow us, it does not matter. So they were ready not to vote, and the Supreme Court did that. The Supreme Court said that though they are not yet disqualified, but they will not be allowed to vote in the trust vote. What happened? The government lost majority. The trust vote was lost and the BJP came to power. Elections were held recent. Last week election results were declared. Out of I think 15 seats or 16 seats, the BJP was able to win I think 13 or 14 of them. So now they have the majority. The question is the role of the speaker, the role of the presiding officer, and this is only one example. This is only one example. There are so many other examples that you can see wherein we find that the Speaker of the House is not a neutral body. It's not a neutral authority. So the question is, when the law gives this power to disqualify to the presiding officer, the presiding officer is a political authority and is very likely to misuse such a power in favor of a political party over the other. Like what was done by the Speaker of the Karnataka. Forget aside what is the political connotations of those ideas. Every political party is there to do it, there to come to power, and they are going to do this. You cannot expect political parties to act as saints. They will never do that. They are never going to do that. But you can do what? You can enact laws or ensure that such political defections that are there, they are not in the hands of the presiding officer. Why? The presiding officer is a political individual. The next question was, which came up in the Supreme Court also. These individuals who had defected from a political party, should they be allowed to contest elections? Because the law does not say that. The law does not say they are prohibited from contesting elections. The law says that they are disqualified from the House. Once they are disqualified from the House, they are going to contest elections. They may again become the member of the House. So the question came up in the Supreme Court. Should they be allowed to contest elections? The Supreme Court said yes. How can you not allow them to contest elections? How can you not allow them to contest elections when there is no such provision in the law? So they contested elections, and these same individuals who initially were the members of Congress returned back to the legislature being the members of BJP. क्या political defection हमने रोक दिया? Question तो ये है ना. The law was, what was the objective of the law? What was the law to do? The law was supposed to curb political defections, stop political defections. The question is, have we been able to do that? The answer is no. Why? Because of some reasons. Now let us look at those reasons. That means, what are the problems with the law and what are the reforms that are needed in the law? Let's look at that. Before you start with that, let's first deal with the paragraph 7 you have written. This final and binding, that is idea that has been there, this has been held to be unconstitutional by the court. So what is the decision of the court? Just in the next paragraph, right? The Supreme Court in the Cogito Holgon 1992 case upheld the constitutional validity of the Anti-Defection Law. However, held the paragraph 7 of the law to be unconstitutional and void. As it took away the power of judicial review. From the judiciary, which is a part of basic structure of the constitution, which is a part of basic structure of the constitution, basic structure of the constitution. The Supreme Court ruled that in anti-defection case, the presiding officer acts as a judicial tribunal, and therefore the decisions are subject to judicial review. Clear? So, though the presiding officer is still responsible for disqualifying, but such decisions of the presiding officer can be questioned in the Supreme Court, or for that matter the High Court. It can be questioned. Clear? Paragraph 7. Now give a subheading, right? Critical analysis of the law. Critical analysis of the law. First criticism. The law does not clarify the status of suspended members. There are two examples that I am going to give you here. First example is with respect to the last Lok Sabha, wherein one of the members of the Lok Sabha, Kirti Azad, who was a member of the Lok Sabha from state of one of the constituencies in Bihar. He was elected to the Lok Sabha on the ticket of the BJP, but after around 1.5 years of completion of his tenure, he was suspended by the BJP. So he had accused the then finance minister Arun Jaitley. Arun Jaitley passed away, but he accused Arun Jaitley that Arun Jaitley, when he was the member of the Delhi Cricket Association, so he was involved in cases of corruption. And he regularly talked about this. Because of this, he was suspended from the BJP. Once he was suspended from the BJP, now neither he was a member from the BJP. He was elected to the house from the BJP. Now he was not qualified to be disqualified under anti-defection law. Why? Because anti-defection law, it comes up with certain criteria, such as you should not leave the party, you should not join any other political party. Neither did he leave the political party, neither did he join any other political party. So he did not qualify to be disqualified from the house. So he continued for the rest of the term from the Lok Sabha. He continued to be an MP, despite the fact that he was suspended from the political party. So see, when it comes to suspended members, what is there? Can they be disqualified or not? Should they be disqualified or not? Because the party has removed them. Similar was the condition of Kapil Mishra in this particular Aam Aadmi Party the legislature of Delhi. So he was initially a part of Delhi government's Council of Ministers. He was water resource minister in Delhi government, Kapil Mishra. So around 2.5 years ago, what happened was he left the Council of Ministers. He was told to resign from Council of Ministers. He resigned from Council of Ministers, and since then he has been acting against the party. So he had accused Arvind Kejriwal of corruption. During the Lok Sabha elections recently, he was supporting BJP. He is a member of Aam Aadmi Party. He was a member of legislature, Delhi legislature from Aam Aadmi Party, but he was supporting the BJP. In fact, he came up with a slogan, 7 seats, and something like this. He was in support of the BJP, regularly criticizing the, Chief Minister Arvind Kejriwal. But he neither left the Aam Aadmi Party, nor defied the whip of Aam Aadmi Party, nor did anything which makes him, which qualifies him from disqualification. So he was not qualified. He did not qualify to be disqualified, but he was disqualified. But he was disqualified. Why? Because the speaker, obviously, presiding officer. So presiding officer disqualified him. See, on one case wherein Kirti Azad continued to become, to be the member of parliament for 3.5 years, being suspended from the political party. So being suspended, he has no opinion. So neither he can go with the Congress party. If he goes with the Congress party, then he is disqualified. To continue as a member, he voted from, in the manner the party wanted, the BJP wanted him to do, but he was not a member of BJP also. He was suspended during that particular period. Similarly, if you look at the case of Kapil Mishra, it was similar. He is also criticizing one of the ministers, chief minister, criticizing the political party, etc., etc., but not resigning from the political party. Neither is he joining any other political party, which technically speaking does not make him eligible for disqualification. But he is still disqualified. So very recently, now the elections are scheduled to end. So he was 2.5 years, he is the member of Aam Aadmi Party. Despite the fact that he is criticizing Arvind Kejriwal, he continues to be the member. And now suddenly, just before 6 months before elections, the Aam Aadmi Party disqualifies him. So what is the status of suspended members? The Anti-Defection Law does not talk about it. It is silent on the status of suspended members. Clear? Second point. We are talking about criticisms. So second criticism. The presiding officer who is responsible to disqualify a member under this act is not a politically neutral officer. Hence, anti-defection is used. For political advantages. Third, laws such as anti-defection is also responsible for representatives and legislators toeing to party lines, following party lines rather than truly acting as the representatives of a constituency. Therefore, we'll be writing this in reforms needed. See this, let's understand this provision it's very important. If you look at the working of parliamentary democracy in India or the legislature as an institution in India, if you look at Article 105 of the Constitution, Article 105 of the Constitution talks about parliamentary privileges. So being a member of parliament, there are certain privileges that are enjoyed by an individual. And one of the privilege is freedom of speech and expression. Unlike the fundamental right that we enjoy, that is freedom of speech and expression, our fundamental right is under what you can say some reasonable restrictions. The freedom of speech and expression that is enjoyed by the members of parliament within the parliament or on the floor of the parliament, that is absolute. There is no restrictions on it. It is absolute. There is no restrictions on it. So I can say whatever on the floor of the house. If I am the member of the legislature, I can say whatever on the floor of the house, and there can be no criminal or civil offense or no criminal or civil suit filed against me for that very purpose, for what I have spoken there. Very recently you must have heard about Azam Khan. Azam Khan taking up a very lewd remark against one of the fellow MPs. That is not the first time. There have been number of such cases. Previously, if you go to the last Lok Sabha, you will find in Raj Sabha, there was one of the MPs of the Raj Sabha, Sharad Yadav, made a very derogatory remarks against one of the fellow MPs. But there can be no civil or criminal suit filed against them. Why? Because they are speaking on the floor of the house, and for that they enjoy complete immunity. Okay? Fine. If they enjoy complete immunity, there is a logic to it. What is that logic? The logic is that because they are acting as members of they are acting as representatives of a constituency. So when they are putting forward the concerns and issues of the members of the constituencies, their constituency, they are going to take up all such concerns, all such issues without any inhibitions. This is the very logic, and that is the reason why even if there is a case like, if I am talking about, if you remember, if I am talking about suppose a particular matter which is right now under sub judice, which means it is under the judiciary. In that case, if I am talking about it in the newspapers and I am trying to frame an opinion, in that case I can be punished with contempt of court. But that cannot be done to an MP that is speaking in the floor of the house. Why? Because they enjoy certain privileges. Why are they enjoying certain privileges? So that all the issues and concerns of their constituency, they are able to put forward those issues and concerns without any inhibitions, without any kind of restrictions. Now, what is the idea of whip? What are you trying to do? You are trying to constrain or curb the rights that they enjoy. Now what happens? Now whip are issued. Now whips are being issued. And now because of those whips being issued, what happens? The members of these political parties, they start toeing to party lines. That means they start following what the political party has to say rather than what the members of their constituency, what the citizens of their constituency want. Let's take an example. In J&K, there are, I think, 5 seats in the Lok Sabha. One seat is from the Ladakh region, 2 seats are from the Jammu region, and 2 seats are from Kashmir region, something like this. 4 or 5 seats are there. Now, the BJP, out of these 5 seats, BJP was able to win 3 of them. The BJP issued a whip on in August 5th and 6th, for August 5th and 6th, and said that every member of the political party, BJP, has to be present there, who has been elected. They have to be present in the house. Now, when J&K reorganization bill was introduced, what happened? J&K, which was previously a state, was deprived of statehood. It was made a union territory. The question is, when the members, what were the members of the parliament, MPs of J&K, specifically those two MPs of J&K, specifically belonging to the Jammu region, because in Ladakh region, yes, they had a long outstanding demand of Ladakh being a UT. So one member of parliament from Ladakh, his wishes are fulfilled. So fine, he will speak for the bill. The question is, when Jammu and Kashmir is being deprived of statehood, in that case, why are these two MPs not speaking against the government? You should criticize the bill. See, it's fine that you have removed Article 370, you can support that. That is absolutely fine. But when a particular area which is previously a state is now being made a UT, that means it is losing the autonomy that it had, because states have autonomy, UTs do not. So it is losing that autonomy. Now it is under, center's control. But did you hear about the BJP MPs speaking against this particular idea in the parliament? No, they spoke in favor of the bill, not against it. This is one of the examples of what happens because of the anti-defection law. The members of the parliament, they are not speaking or not taking up issues and concerns of their people at large. They are talking about what the political party wants them to speak, rather than they speaking in favor of the issues and concerns of the people. There are 303 MPs of BJP. No one is speaking about the status of economy in the parliament. Do you think that the members of the constituencies that are there, of these MPs, they are not facing problems with respect to economy? They are also facing the problems, but who is questioning the government? No one is questioning the government. These MPs are not questioning the government. It is the, okay, fine, opposition, but in terms of numbers of opposition, they are very small. So the biggest party has 52 seats, 53 seats. This is the number. So when we talk about the parliament, remember, how did I introduce the topic? I said that parliament, though it has the primary function of law making, it also has a function to ensure the accountability of the Council of Ministers. Now, is the accountability of the Council of Ministers being ensured? No. It is because of these laws such as anti-defection law, that these things, the effectiveness of the parliament, the effectiveness of the debate, discussions, deliberation in the parliament is it is being compromised with. It becomes ineffective. This is the reason. I'll give you one more example. Let's go back to 1956. In 1956, one of the members of the one of the members of the Lok Sabha, he raised a question against the then government. So there was a finance minister, T.T. Krishnachari, and that T.T. Krishnachari, what had happened was, the LIC, there was somewhere around an amount of 1.5 crores which was missing from the LIC. So one of the members of the parliament questioned the finance minister. Where is the money? Who is to be held accountable? The T.T. Krishnachari alleged that it was the finance secretary, and the finance secretary said no, this minister was involved. They were fighting with themselves. Because of this MP's question, T.T. Krishnachari had to resign as the finance minister. Who was the MP, you know? Feroz Gandhi. He was the member of Congress. The MP who raised this question against the Nehru government was Feroz Gandhi. He was a member of Congress party. He raised a question against his own government. And that led to the resignation of the finance minister. This is a contrast of what happens with the laws such as anti-defection law and what was the case when laws such as anti-defection law did not exist. I am not saying that anti-defection law is to be blamed. There is also the political tradition, etc., etc. And I am not so supporting a political party. What I am trying to put forward is the fact that there is a need for reform in the anti-defection law. Because if we do not reform this law, what is going to happen? This law is being used in a manner so that it leads to political gains for the political party in power. This is what happens. What are the reforms? I'll be discussing in the next class. Clear? I'll be discussing the reforms in the next class.